Hi everyone, hope you're all doing well this week. Just want to talk a little bit. I'm going to stray from what's in the main text, the longest text for our class, and talk a little bit about the basics of law that we just don't get in this class. We talk a lot about policy and politics, but from that particular text, there's an assumption that you have this basis in law already. So since we don't cover that in our program other than this class, I just wanted to talk a little bit about it because as an administrator in the healthcare system, you'll want to be knowledgeable about these types of things. So first, remember, I think it was last week or the week before, I talked a little bit about the difference between public and private law, statutory law, administrative law, and common law. But in this case, what we're talking about are some of those elements of statutory law. So the majority, actually, I think everything that we're going to talk about here are considered private laws because it's issues that deal with individuals as opposed to the government and an individual or the government and a company. So these are mostly private laws, but they are rooted in statute. So these are the types of things that our statutory law legislators, most of the time, many years ago, long before any of us were around, created these laws, and we still use them and interpret them today. And you'll see through this is a very long presentation or a very long set of slides. Probably won't go through every slide, but I will post this in the classroom so you can see the other slides, and lots of information in here that will hopefully be helpful. So the first type of law that I want to talk about is tort law. So tort law is when someone has been wronged. So there's kind of a set of criteria that you need to meet in order to have violated tort law. But these are generally civil actions, and in this case, what we're talking about are tort law involves those types of things where there are some damages of some sort, and a person can sue for those damages. So the purpose of tort law is really to hopefully keep and create peace between people, find fault for wrongdoing, to deter people from committing these torts, and then to indemnify folks that are injured. Think malpractice. So it provides compensation to folks that are injured under a violation of a tort. So the one that we think of most often or gets dealt with, I'm going to say most often, I don't have actual stats on that in front of me, but from my work in the legal world of in healthcare, when I was in compliance, I can tell you that the majority of cases that we litigated were negligence. So negligence is when there's an unintentional commission or omission of an act that a reasonably prudent person wouldn't do or would do, depending on the situation, under given circumstances. So think about malpractice. Malpractice is negligence, and we'll take a look at a couple of cases. So the types of things that are considered commission of an act, and we actually have one this week in our discussion, administration of the wrong medication, wrong dosage, wrong patient, no consent for surgery, wrong body part, wrong patient, wrong surgical procedure. So those are the types of things that a reasonably prudent person would not have done that, so it is considered negligent. On the omission side, we're looking at things like failing to conduct a physical, failure to administer medication, failure to order diagnostic tests, and that leads to defensive medicine and over ordering of tests, because if you're found to be deficient in what you've ordered, you may be culpable in a negligence claim. So those types of things are considered omission of an act. So malpractice is very specific. So it's considered negligence or carelessness by a professional. So in our world, we're talking about nurse practitioners, physicians, physician assistants, pharmacists. Our example that we have here on the slide is someone that conducts a surgical procedure on the wrong body part. It's considered negligence under the tort law, but there's very specific negligence called malpractice, which is specific to those professional people. And as we look at our discussion this week, I think it's our discussion. It's either discussion or written assignment. But regarding the nurse in Tennessee, in the past, the potential existed that the organization could have been brought up on charges of negligence or malpractice on the part of the patient who died at the hands of this professional that was negligent in their work. However, they're actually prosecuting her as a criminal, that it's a reckless homicide. So that's a big difference, a big change in our industry, and hence the reason that we're talking about it. There are elements of criminal negligence. So these here, as we talk about it, sorry, there we go. This is typically a civil case. So think of I'm seeing a lot right now, at least in the Pittsburgh market on television, that Roundup weed killer. So Roundup weed killer is found to contain a carcinogen. Many people are dealing with cancer secondary to the use of that Roundup in their work or in their personal life to kill weeds. And so what this class action case is saying is that the people in the class, which are all the people that have been injured, that the folks that make Roundup, I'm not sure who it is, Monsanto or some big chemical company like that, was negligent in their work. They were negligent. They didn't tell us that it was dangerous. I've seen some regarding talcum powder as well, related to ovarian cancer. So those types of things are civil suits. There's nobody from Monsanto or whatever company it is likely to go to jail, but they may have to pay millions and millions of dollars to those that were harmed at their hand. Criminal negligence is a little different in that reckless disregard has been shown for the safety of another and willful indifference to an injury. Now, there have been cases in the professional setting where that has occurred. That there was a reckless disregard, which often happens in a malpractice case, but that there was complete indifference on the part of the person that committed the negligent act or omitted the negligent act to any injury that followed that. That could raise it to the level of criminal negligence, and therefore the person involved that committed the act or omitted the act could be tried as a criminal. But it would still just be a tort. It would be a criminal tort. It wouldn't be homicide, etc., is what we're seeing in the Tennessee case. Tennessee law is allowing them to do that, and most states have that same option. That's why that case is pretty important. So a few different forms of negligence, very close to what we were just talking about: malfeasance, misfeasance, and nonfeasance. So you think about malfeasance, mal meaning bad. Malfeasance is the execution of an unlawful or improper act. So doing something, a malfeasant act in some way, is actually doing an act, taking part in an act that is unlawful or improper. A good example, performing a partial birth abortion in the third trimester in areas where that's permitted or where that's prohibited by law. So if that's prohibited by law, regardless of of the situation surrounding the case, it's prohibited by law. If, as a professional, you take part in that, that would be malfeasant on your part. Misfeasance is a little bit different, and this is what we see a lot of the time in the malpractice world. Misfeasance is improper action or improper performance of an act. So doing a wrong-sided surgery, giving a medication improperly, giving the wrong medication, those types of things. So improper performance of an act is misfeasance. Nonfeasance is that omission that we talked about. So failure to act when there is a duty to act. So you have a duty to appropriately analyze the patient's condition, the patient's symptoms, order tests, give prescriptions, etc. And if you as a professional did not do that, you would be considered nonfeasant. There's different degrees of negligence. I'll skip over that. But here are the things that are really important from a negligence standpoint. In order to be able to prosecute in a negligence case. So a lot of attorneys that work negligence cases will look at your case for free. And they'll make a determination as to whether these four things exist. If these four things exist, then they may take your case. And then you pay based on contingency, meaning if you win and get money, they take a percentage of it. That's why the malpractice world works in that way. It's very easy for that to work in that way. The four elements are that there was a duty to use due care. So, for example, if I was walking down the street and someone fell in front of me, had a heart attack, and needed CPR, and I did my best to save the person, I didn't have a duty in that case. I'm not a healthcare professional in a clinical sense, so I didn't have a duty. If that patient died, I couldn't be sued by that family. There's other protections for most people, even healthcare professionals in those cases. But let's say it happens in the hospital. Someone falls, a patient or a visitor falls in front of me. I start CPR because I note that it's something that's needed. If I can't revive that patient, I have no duty, so I'm not negligent. Whereas if a physician is performing a surgical procedure and accidentally nicks the patient's aorta in the process, he had a duty to care. And the standard of care in that surgical procedure is not likely to nick the patient's largest blood vessel. So that would be, they would not have met their duty to use care. So that is the breach of duty. So you have to have a duty to care. So you have to, what is the level of care, standard of care for that situation? Was there a breach of that duty? So you, in the case of the aorta, the surgical procedure, patient's aorta was nicked, patient bled out before they could fix it, and died on the table. So they had a breach of that duty, and then that goes into the third item, that there was an injury or actual damages. Sometimes someone will do something. What's very common in abdominal surgery is, they'll move things around to be able to get at what they're looking to get at. And sometimes those things don't wind up exactly where they're supposed to be when they're done. Many, many years down the road, that patient may end up with adhesions or problems. And oftentimes that is not considered, unless it causes significant problems for the patient, it's not typically considered malpractice because they didn't incur any actual injury at the time of the surgery. Within a normal realm, it was 20 years down the road, and every patient's going to have adhesions and scar tissues in their abdominal cavity if they've had abdominal surgery. So in that situation, there would not be an injury. So you wouldn't meet that element. There were no actual damages that were caused to the patient at that time. And then that's where we get into the fourth element of causation, that you need to be able to show that the act or omission of the act is what caused the injury. So, for example, if the patient had 2 or 3 surgeries right within a short time period and was found to have some kind of surgical implement, a sponge or some other surgical implement left in their abdomen after those surgeries, but they didn't know which one. That could be a problem with causation. They can't, they would probably sue them all and then let the courts sort it out. But there was clearly there was a duty to use care. You shouldn't do that. You shouldn't leave instruments in the patient. There was a breach of that duty because they did. There was an injury, likely the patient had an infection or something like that that came up, and that's how they realized it was there. But what's the causation? Who actually caused the problem? And that's where an investigation and a trial would likely turn that up down the road. So we've talked about these already. The one thing that I do want to mention, all of these elements, the duty to care, breach of that duty, the injury, and the causation are all based on the assessment of a reasonably prudent person. So would a reasonably prudent person have thought there was a duty to care, have seen that breach of duty, have understood the injury, etc. So it's a hypothetical person, non-existent person, but they are the community ideal. They are the who considers what things are reasonable and what things are not. So that's how that goes forward. So I'm going to skip some of these. Like I said, I'll put these in. You can take a look at them, and it's also in your reading, not in the main reading, but in the other text reading that is posted for this week. I'm going to skip over the ethics section, but I will mention this. So there was a case, we'll look at this one. So there was a case that was around hiring practices. So nurse was hired sight unseen over the telephone. The applicant said that they were licensed as an LPN, but the employer did not verify the employment. And then the person that said they were a nurse had committed 56 criminal offenses of theft prior to their employment, and ultimately ended up assaulting a resident and breaking the resident's leg. So this is a case where we're looking at duty. Was there a duty of the employer to make sure that this didn't happen? So typically in hiring practices, in most settings actually, but especially in healthcare, employers do have a duty to validate that a nurse, a physician, therapists, technicians, etc., have a professional license or a professional certification. I mean, even if you look down to the level of medical coders, which is something I am certified as a medical coder, and I know that if I go to work to do coding for somebody, they're going to contact the AAPC or AHIMA, which are the two organizations that certify most of us as coders, and make sure that I actually have the certification that I say I do. They'll most likely ask you for a copy of your transcript from your latest, if you put down that you're a college graduate from the master's program at Robert Morris University, they'll probably want that. They'll want that transcript, or at least a copy of your diploma that shows that you've graduated. So there is a duty on the part of the employer to validate licensure, certification, education, and when you fail to conform to what is owed to the public. So in this case, a reasonably prudent person would say, well, gosh, yeah, you would always verify a nurse to see if their license was good, etc. You have a breach of that duty. So I'm not going to review. The Hastings case is actually in the reading, so I won't take a look at that. But other breach of duty situations, physician fails to respond when they're on call. A lot of times surgeons, maybe trauma surgeons, specialists like orthopods and neurosurgeons, neurologists will be on call for the emergency department, and they're being paid for that duty. And if they choose not to respond when they are called, that could be considered a breach of duty if there was an injury to the patient. So we already talked about that. So here's the injury element of that hiring practices case. We already talked about the situation. Patient was injured. The patients had their leg broken and they were assaulted. So the hospital, or in this case, I would guess that since they're referring to the patient as a resident, I would say it's a skilled nursing facility or some other type of long-term care facility. The hospital or the organization is what's called vicariously liable. So vicarious liability means that the patient's family, the patient themselves, is not able to sue. They're not going to sue this, and sometimes they will be named in the suit, but it's not successful. Most of the time, these folks, they're just like you and I. We don't have millions of dollars lying around to pay out on a lawsuit of this nature, but large organizations sure do. So this is a situation where that hospital is considered vicariously liable for the conduct of this professional that they put in place without verifying that there was some kind of issue in their background. Now, there may be people that would argue, would this criminal offenses of theft, would that drive us to not hire a person because would we see that this would have happened in the future? Well, if they've had 56 criminal offenses of theft, they're probably not a good candidate for hiring. If you have committed a small infraction in your past and you show progress to rehabilitation, I think that makes good sense. But in this case, patient committed 56 criminal offenses in the past. We didn't know that. We didn't look at it. We did not verify their license. With that type of background, it's unlikely that the state would license them as a nurse. So therefore, there is certainly an injury that occurred here, and the hospital would be, or organization would be considered vicariously liable. Now, in this case, the patient was assaulted, so there could very well be criminal charges against that employee, because there was assault and battery in that case, which we'll talk about in a little bit. Causation. So we talked about the causation part. Causation is about proof, the reasonably prudent person being able to prove that, or if a reasonably prudent person looked at the situation, that they would see that the act or the breach of duty caused the injury. So in this case, it does seem that the breach of duty could have caused this. They should have verified that the patient or that the provider was an LPN. They should have done a background check on them, and ultimately this resulted in an assault of a resident and the patient being injured. So it is reasonable to state that there was causation there. They departed from what would be considered normal, recognized standard of care, and there was an injury that occurred. I'm going to zip over foreseeability. Here's just another general example. We talk about surgery a lot as being where negligence and malpractice happens, unfortunately. So this is an example. Dr. Smith owns the local outpatient surgery center. He instructs employees to count all instruments, sponges, following a surgical procedure prior to closure. Annie, who was an employee of the facility, failed to conduct the count on Bill, who was having surgery. 2 months later, Bill started having extreme abdominal pain and was found to have sponges and instrument in his abdomen, which caused an infection. So in this case, will Dr. Smith, who is the owner of the facility, will be liable for Annie's negligence? Well, yes, that notion of the doctrine of vicarious liability that we were just talking about, although Annie was the one that was tasked with that, Annie was to count the sponges, surgical instruments. She did not. So therefore, there was a duty to act. There was a breach of that duty. There was clearly an injury. If we look at the issues that Bill started having, and it was caused directly by her actions. So the employer is vicariously liable for her actions. Now, sometimes there will be situations where a person is acting in a criminal nature outside of the scope of their work, and there would not be liability on the part of the hospital. But the majority of the time in malpractice cases, you're looking at hospitals and healthcare organizations being vicariously liable for the actions of their employees. And it's an important point, and especially for those of you that are interested in working in HR, I know that we have quite a few. It's very important that we have very strict hiring practices, making sure that we're only getting the best candidates for our positions, and that we're double checking every element of what they're stating on their resume. The majority of people will always be honest about their resume, but there are people out there that won't be, that will just place things on their resume that didn't happen, schools they didn't go to, jobs that they didn't have, etc. So it's very important that we check references, verify licensure and certification, verify education, etc. Very important element. We're not going to do that activity because we're not teaching this live in the classroom. If we're in the classroom, we would do that. So we've been talking a bit about negligence as a tort, but there's also a cadre of what are called intentional torts. So these are torts that are seen obviously very often outside of these. None of these are very specific to the healthcare setting. We just see their use in the healthcare setting. Intentional torts are things that there are rules that govern this element of the law overall, and we see them applied to the healthcare setting, like assault and battery. Good example is that case we were just looking at. There was negligence in that case on behalf behalf of the hospital or the physician practice that owned that surgical center. However, there was also assault and battery, which is considered an intentional tort. There could be criminal charges brought, but there could also be civil charges brought under assault and battery law, not under negligence law. So lots of different ones. We'll just zip through these pretty quickly. So assault and battery, it's kind of important to know the difference of these things. So an assault is when there's a threat of some action, let's just say a threat of battery, and coupled with the apparent ability to do harm. So assault does not necessarily involve actual physical contact. So for example, if a small child were to come up to a full-grown man and say, you know, I'm going to knock you out, that would not be considered assault because there was a threat, but it's unlikely that that small child would be able to do physical harm to a full-grown man. So there certainly could be the first half, that threat half, but it would not be considered assault. On the flip side, battery is actual intentional touching of another's person in some manner that's not appropriate without that person's consent. So if I were to walk up to someone and punch them in the face, that would be both assault and battery, because I may threaten them, hey, I'm going to punch you in the face, and then battery occurs when, you know, when the action actually happens, which of course I would never punch anybody in the face, but it happens. The healthcare example, you might think, how does this have anything to do with healthcare? Well, there are plenty of times when we lay hands on patients, perhaps when they're not interested in that. So failure to obtain consent prior to surgery, administering blood to a patient that does not want blood administered, physically restraining people. Those can all be considered battery if not done in appropriate circumstances, like, for example, physical restraints. There are appropriate times to use them, not as much as there used to be, because they have really cracked down on what is considered battery and have better defined when it is appropriate to restrain a patient if they're belligerent, injury to staff, those types of things. But failure to obtain a consent. Well, how do you avoid that? Well, you get consent from the patient prior to operating on them, etc. So all situations of potential battery. False imprisonment is another one that we were just talking about restraints. So this is an important one. It's unlawful restraint of someone's personal liberty or unlawful restraining or confining an individual. We think about situations where typically patients are free to go from our facility. They can always leave against medical advice. We may advise them, request that they stay, etc. But we can't force them to stay. Everyone has their own free will. But there are situations where we may try to force them to stay. For example, if they have a highly contagious disease like Ebola. One would hope that they would want to stay and try and be treated, but we certainly do not want them to go out into the street. Another situation might be intoxicated persons. They may be so intoxicated that they could cause injury to themselves, and we may try to keep them in-house. However, without appropriate paperwork from the police department, in most cases, we can't keep them. They do have their own free will. Same with restraints. You may have a patient that maybe has a behavioral health issue or is intoxicated and they are belligerent, but there's only very certain situations where we can use physical or chemical restraints in the healthcare setting due to the fact that it would be considered false imprisonment and potentially battery as well if it's a physical restraint. So it's important that we follow the guidelines that our organizations have put forth with regard to keeping patients against their will or restraining patients. Very important. Some of the justifications that exist, like I said, that highly contagious disease. Patient has exhibited criminal conduct, so if the police are there with them, we may have to restrain them or seclude them. Or if they're a danger to themselves or to others, those are the situations where we may get the police department involved to have it depends on your state law in those cases, but to have them put in place paperwork that says that we can keep them in our facility because they could injure themselves or injure others. Defamation of character is another intentional tort that we deal with in the healthcare setting. So, defamation is about injuring a person's character, reputation, by stating false or malicious statements. So, it could be something that we say, it could be something that we write, but it injures a person's reputation. And so there's two different forms of defamation of character. Slander, which is the oral form, when you're speaking, saying something that is injurious to someone's character, or libel. So that's our written form of defamation. So it could be a letter, it could be social media, it could be photographs, cartoons, signs, whatever it is. The thing that's important with regard to defamation of character, be it libel or slander, is if what you're saying is true, then it's not libel or slander. So you could say, let's say, somebody comes out and does a whole social media campaign about one of the physicians in your facility, saying how he's not a good physician. These are the rates of infection that he has. These are the number of patients that he has injured in surgery, et cetera, et cetera. That would not be libelous or slanderous, depending on if they were out there. If it was a social media campaign, obviously it would be libel because that would be written, but maybe they're out there saying those things as well, so it could be slander. That wouldn't be libelous or slanderous because if they're showing facts, it's true. Whereas if there's a personal beef between a physician and a patient, and the patient goes on a rampage, or maybe about your facility, a patient goes on a rampage on social media saying how everyone that goes to that facility is injured in some way, and don't go to see that physician because they're just inappropriate in ways that could be problematic for their character. If maybe if let's say it's a pediatrician and the person comes out and says, well, that guy's a pedophile. Well, that would be horribly injurious to that patient or to that provider's character, because nobody's going to want to take their children there. If it's true, then obviously they can say it. There's no defamation of character. But if it's not true, we don't have just the right, we have the right of free speech in this country, but we don't have the right to injure people's character in that way. And if they can prove that it happened, especially with libel, it's more difficult because that's an oral statement. But if we can prove that it happened and prove that there was intent to harm, which obviously there was in many cases, the patient or the person could, flip-flop that, we're talking about the provider. The provider could potentially file a defamation of character suit against whomever said the false statement and obtain damages. And they would typically be monetary damages. Unfortunately, in most cases there isn't going to be the ability to obtain funds from a private individual. They don't typically have insurance that covers those $1 million settlements. However, it could help to repair their character if they were able to have a case that showed that whatever the patient said or whatever the person said about their character was untrue, and that can be very helpful in itself. So this is just a silly little example, but Jack draws a cartoon depicting Paul stealing items from a patient room while they sleep. The incident never occurred, and this was placed in a cartoon in a newspaper. So is there some type of defamatory statement? Is there a defamatory statement there? Well, yeah, because in this case, Paul was shown stealing items from a patient room, but Paul didn't steal any items. There was no reason to think that he would. So how would we put this forward under the law? Well, it would be considered defamation of character. In this case, it would be slander because it would be a written statement. Like I said, there is no, if something is true, that it will not go forward. That is the best defense to defamation of character, is to prove that what you've said about the patient or written about the patient or about the facility or about the person is actually true. And if you can prove that it's true, then there is no liability for you in a defamation suit. Fraud. So fraud is another one that we deal with a lot in the healthcare setting, sadly. And fraud is a willful and intentional misrepresentation that could cause harm or loss. So when we think about the healthcare setting, oftentimes we see fraud with regard to payments from insurance companies or from the government. There's a very important law called the False Claims Act that comes into play when we're talking about government. But there is certainly fraud with regard to private insurance payers, et cetera, as well. So a good example is a physician creating fake documentation to support billing for services not performed. So there are many, sadly, we see them across the country, and it's a good example of payers not doing their due diligence to verify provider credentials. But we'll see someone set up shop as maybe a pain management clinic or as a physical therapy or something like that. They'll get themselves a provider number. They'll get credentialed somehow with these organizations, typically because the payer is not doing their due diligence to vet the provider and make sure that they have the licensure they say they have. And then they'll just they'll find ways to steal insurance numbers from patients, say Medicare patients or private payer patients. They'll get their insurance information and bill for services that were never even rendered. They've never seen the patient, they've never met the patient. So those types of situations are these kind of fraud mills that exist out there are costing our industry billions of dollars every year. So something that we really need to move forward on cracking down on, but this is a good example of that. Another option is, or another one of the intentional torts is invasion of privacy. So obviously we know in the healthcare world we have HIPAA, and HIPAA protects the privacy and security, amongst other things, of patients' protected health information. However, there is no personal right to action under HIPAA, so I can't sue someone because they breached my medical records, they breached my identity, social security number, those types of things. However, there is a separate intentional tort called invasion of privacy, and this is what usually comes into play when we have a patient confidentiality breach and the individual whose information was breached wishes to sue. So invasion of privacy is a situation where someone's personal privacy has been invaded, period. And we have a right to be free from unwarranted publicity, exposure to public view, and sometimes that a HIPAA violation will end up in those situations. Another intentional tort, intentional infliction of mental distress. So it's a situation where it's kind of like bullying. Conduct is so outrageous, goes beyond the bounds tolerated by society, causes mental suffering in the patient, grief, shame, public humiliation, despair, etc. So when a good example of a case, and I believe the case is further detailed in the text information that you have in the classroom, but this was a good case of infliction of mental distress. A mother was shown her premature infant that had passed away, and this was, it wasn't as if they had requested to be shown the baby. They were just, here they are. It caused an inordinate level of mental distress for the mom, and ultimately she sued the facility in that case. So we certainly would never want to cause someone mental distress. We're actually there to do the opposite in the healthcare setting. But sometimes the inappropriate actions on part of our providers, et cetera, that can happen. Product liability is another intentional tort that we deal with in the healthcare setting. If you work for a medical device manufacturer or a pharmaceutical company, you may end up in the situation of a product liability case where there were injuries sustained because of a defect in a product. So I think about there was quite some time ago, Medtronic had some problems with some of their pacemakers. There was a huge product liability case against Medtronic in that case, or in that situation, because the pacemakers were not functioning properly, causing patients to go into inappropriate rhythms, die, etc. So very problematic. Medtronic was sued for lots of money by lots of people because of the defect in their pacemaker. So when we're talking about product liability, you need to show that there was negligence on behalf of the provider, be it a medical device manufacturer. Sometimes pharmaceutical manufacturers have devices that have defects, or maybe the pills that they create have defects. They have to show that there was some breach of the warranty that there would be with that device. So, for example, let's say a pacemaker battery is only supposed to last for 2 years. This patient's had their pacemaker in for 6 years and hasn't had the battery changed. Well, if the thing starts malfunctioning, it's not likely going to be legally shown as the fault of Medtronic. It's the fact that they were outside of their warranty realm. So that's an important element of the situation. They're also strict liability, so meaning that you're not going to get millions and millions and millions in extra damages. You're typically going to receive the amount of money that is shown that what the injury was, what the harm was done. These are strict liability cases. So this is an interesting example that we have here that kind of demonstrates that product liability. So a defective x-ray unit. Mindy places Candace, who is the patient, on the table of their brand new manufacturer installed x-ray unit. While in the control room, obviously Mindy's going to go to the control room to hit the button for the x-ray. The tech is not going to be in the room with the patient. But she went to the control room, she heard a crash. She rushed to the patient and found that a part of this brand new, newly installed x-ray unit fell on the patient, further injuring her already broken leg. And Candace sues the manufacturer for negligence. Could Candace recover damages in that case? Well, yeah, actually, she probably could, because there was a duty to act. The manufacturer should have properly installed the unit. There was a breach of that duty. The injury is there. Obviously, the leg. The break of the leg was made much worse by this unit falling on it. And then also there was causation. The fact that improper installation, sorry about that, the improper installation of the x-ray unit ultimately caused the patient's injury. So that was a brief run around the types of tort law that we face in the healthcare system. All really important things to be aware of as an administrator, etc. So this week we are talking about the Vanderbilt nurse case in Tennessee, where a nurse is being prosecuted for reckless homicide related to a med error. You've got several articles and pieces of information up there. There have been a couple similar cases that have occurred since, but this was kind of the first of its kind, or one of the most high-profile first of its kind. So important to be aware of. We're also still looking at the policy side, and so for our writing assignment this week, we will be there is some information out here about kind of tying it back into our opioid process. Remember, as we talked about, I think it was in last week's video about administrative law and how that process works. We're in the Federal Register, there are either proposed rules or requests for information posted where we are looking to, as an industry, we are looking to provide input to the government on various rules that they may be putting in place. Back on June 21st, the FDA put out a new framework, future opioid analgesic approvals and incentives for new therapeutics to treat pain and addiction. So the Federal Register is here. Some information about the FDA framework is here because that's what's being proposed. So what I'm looking for you to do this week is to look at the Federal Register document. It's lengthy, but if you scroll all the way to the lower part, where they're actually showing the changes to the rule. And then also look at the framework itself, which is probably more important. And provide some comments to the FDA on these areas, especially given your, the work that you've done in examining the opioid crisis already in this classroom. So take a look at that. Let me know what questions you might have. And then obviously we have our quiz for this week as well. The assignment itself is here. Your Dropbox is below it because it is a Turnitin Dropbox. I'm hoping, I had some fairly significant issues with Turnitin. I couldn't access your assignments, but I'm hoping that those, once I was able to access them, then I couldn't grade them. It just kept freezing up my screen. So I'm hopeful that that's resolved. But in case that there's further issue with that, or if you have issues submitting your assignment there, let me know, and I will address it in a different way. We'll have you submit the assignment in a different way. So that's all I have for this week. But I'm sorry, we're a little lengthy, but that was a lot of information that you won't get in any other way. So hopefully it's helpful. Please let me know what questions you have. And that's all I've got. So we'll talk to everyone in the Flipgrid. Thanks.